All right, in that case, then let's begin the sixth session of this hearing, where we will be hearing today from the various financial and valuation experts. A couple of administrative notes before we begin. The tribunal has been discussing how best to approach the post-hearing submissions that it was agreed would be done in lieu of closing arguments. Now, we are going to be deliberating tomorrow. We have begun to formulate some questions that we would like you to address, but I think we've decided it would be better for us to sort of see what may emerge in our deliberations tomorrow and then be able to formulate the questions to you more precisely. That said, it would be useful for us to have from you at the end of the day today, from each party, an oral indication of the nature of the final written submission that you would regard as most useful from your perspective, aside from whatever questions we might elect to put to you after our deliberations tomorrow. So at the end of the day, we would like an informal indication. This is basically just for the guidance of the tribunal as it determines the sort of post-hearing submissions that we will be ordering. Is that clear all around? Okay.
It's clear.
Final administrative thing, some days ago I did ask that, I think it's R1, the treaty, or the agreement, be put in all three languages. And I don't know if that has happened, but if not, we do request that be done. We do not need the full however many hundred pages, but the investment provisions and any other sort of final provisions that may be relevant to understanding the text. Is that clear? Can somebody do that? I think it is. I think it's a respondent's exhibit. Is that right?
Yes, sir. And I understand that it has been already submitted.
It has been submitted. Okay,
as
that's great.
RLA 10.
Okay, very good. All right, thanks.
Mr. President, I'm not sure.
All right, well, we'll sort this out offline. But if it's in, great. If it's not, we need it. We'll sort that out. All right. Any other administrative matters? If not, we will turn to the experts. Now, here it was agreed that in the examinations, either expert could respond to a question, but that decision having been made, it is irrevocable, and we cannot have multiple experts responding to a single question. So if the experts can determine as between themselves who will answer a question, and at that point the other glues his mouth shut irrevocably. Is that clear and agreed all around? That was the subject of some discussion. I think that's where we are. Okay, with that, gentlemen, welcome. Could you introduce yourselves for the record, and then we'll go through the formality of swearing you in prior to your report. You then are all familiar with the procedure. You'll be cross-examined, and then there will be the possibility of redirect. If at any point you need to take a break, leave the room, let us know, and we will seek to accommodate. Is everybody okay with that? All right, could I ask you each separately to read out loud the expert's affirmation that should be on the desk before you?
Yes, sir. I solemnly declare upon my honour and conscience that my statement will be in accordance with my sincere belief.
Thank you, sir.
I solemnly declare upon my honour and conscience that my statement will be in accordance with my sincere belief.
All right, and so as to assist the reporter in knowing who's talking, could you introduce yourselves?
My name is Eric Van Dovenborder.
Is your
Eric
mic-
van Dovenvoorde, a partner at Accuracy.
Edmund Richards, also a partner at Accuracy.
All right, now I understand you will be giving us a 30-minute report. Is that the case?
Correct.
All right, over to you, gentlemen.
Thank you. Good morning, members of the Tribunal. As I said, my name's Eric van Dovenvoorde, and to my left is Edmund Richards, and we are the damages experts instructed by the claimant in this matter. Now, I think it's useful to give some background which is important to Quantum in this matter. First of all, that in October 2012, claimant acquired the Invicta project and attributed over 10 million Canadian dollars in value to it. Subsequently, they worked to commission reports and studies relating to the mine, carried out a number of pre-production activities, including tests, bulk sampling testing, and pre-production runs. On the 30th of June 2016, indeed, they obtained a financing agreement with PLI, and one of the precedents to receiving the first instalment on that loan agreement was a road access agreement with either the Laksanga or Paran communities. And indeed, in 2017, claimant signed a surface rights agreement with Laksanga. Following that, in April 2018, they engaged SRK, a leading mining and exploration consulting firm, and they published a PEA on the project. The PEA was defined by a 6-year operating plan at a production rate of 355 tonnes per day. Indeed, SRK also provided a financial model which valued the PEA mine plan at US dollars 43.4 million. And we know that SRK concluded that the project was of considerable merit and demonstrated positive PEA results. Following that, claimant planned to acquire the Malai plant with the aim of increasing production capacity, reducing processing costs, and resolving the issues with third-party toll processors. By September of that year, draft contracts for the purchase were substantially complete, and an amendment to the PLI loan agreement had been drawn up for further funding of $13 million. Furthermore, Red Cloud was instructed to update the SRK model, including an estimate of additional capex required and an increase in production and processing capacity to 590 tonnes per day over a 7-year period. Red Cloud also valued the project at a net present value of 86.3 million US dollars. However, as we know, because of the blockade, claimant's acquisition of the Malai plant was never completed. On this slide, I set out the alleged breaches. You'll be familiar with them, so I won't spend much time on them. Simply to say the claimant's case is that Paran's actions and respondents' omissions caused the loss of claimant's investment. So what did we have to do in terms of damages? We were instructed to assess damages incurred by claimant as a result of the breaches as at the valuation date, which is the 26th August 2019. And specifically, we were asked to do that by reference to the fair market value of claimant's lost investment in Peru. In our second report, we were asked to review the comments from Alex Partner's first report and also to update our damages assessment in light of new information, including the MICON report, MICON being the technical mining experts engaged by the claimant. Now, in line with the principle of full reparation, we assess damages as the difference between the but-for situation and the actual situation, standard approach. We assess the value of the actual situation to be nil. In the but-for, as I said, we assess the fair market value of claimant's investment, and we did that using a DCF approach. And we did it for both the scenarios, the 355 tonnes per day scenario and the 590 tonnes per day scenario. In our preparation for the hearing, we received reviewing our models. We noticed a small inconsistency in our assessment, which was set out in Accuracy 2. As you can see from this slide, it just marginally reduces the assessment of damages before interest to a range of $31.5 million to $40.4 million. We also benchmark our damages assessment to other indicators of value of the project, which supported the reasonableness of our assessments under the DCF approach. Now, Alex Partners, in their report, they disagree with a number of areas of our work and our report. Firstly, they refer to fundamental flaws, which they say, if remain unresolved, would mean that the value of the project would be nil. They also disagreed and challenged some of our inputs into our valuation. And they also disagreed with our other indicators of value, saying that they're either inaccurate or do not demonstrate the reasonableness of our damages assessment. We disagree with those, and in the remainder of this presentation we'll set out for the benefit of the tribunal why.
Thank you, Eric. Good morning, members of the tribunal. Alex Partners allege 4 fundamental flaws.
Sir, could you get a little closer to your microphone,
Yes.
please?
Bring it closer.
Thank you.
Is that better? Perfect. Alex Partners allege 4 fundamental flaws in our quantification of damages. Firstly, that removing the alleged breaches would not resolve the access road protest. Secondly, our failure to account for the remaining social license risk. Thirdly, even absent the alleged breaches, they opine that claimant would have defaulted on the PLI loan. And fourthly, our failure to account for difficulties in refinancing. Based on these fundamental flaws, they conclude that claimant's damages are nil. The alleged fundamental flaws largely pertain to liability issues, upon which we are not qualified to opine. However, to assist the tribunal, we set out our limited comments on the following slides. In relation to the first 2 flaws, Alex Partners opine that intervention by the police appears to have been unlikely to permanently resolve the blockade or the conflict with the Paran community, and that our damages model omits related costs and delays. They further state that no evidence was provided to support the assumption that claimant would obtain and maintain social licenses to operate with all of the affected local communities, and that claimant's failure to do so would negatively impact its operations and could reduce damages to nil. Now, these comments assume that the tribunal finds that the actions of Paran are not attributable to Peru. We note that claimant had signed agreements with the Laxanga and Santo Domingo communities, and it is not clear why Alex Partners extrapolate the issues with Paran to all of the affected communities. We further note that the PEA mine plan prepared by SRK included $1.2 million of capital expenditure related to community infrastructure and $3 million of community relations costs over the 6-year mine plan. Alex Partners calculate an impact of $2.4 million in the 590 tonne per day scenario for the cost of obtaining and maintaining an agreement with Paran. We've reviewed this calculation and we consider that it contains errors that overstate the cost. To the extent an agreement with Paran was required and related costs not already included by SRK, we include a sensitivity later in this presentation to assist the tribunal. Turning now to the last 2 flaws relating to financing, Alex Partners believe that even without the blockade, claimant would have defaulted on the PLI loan under both production scenarios. Firstly, because of the DO4 report's conclusion that Mycon's production schedule, which assumes a start date of November 2018, is not feasible, and that missing approvals would have prevented claimant from exploiting the Invicta project before July 2020. Secondly, because Mycon provided no specific basis for their assumption that issues at the third-party processing facilities would be resolved. Thirdly, that claimant had committed 14 defaults under the PLI loan, several of which were unrelated to the alleged breaches. And furthermore, under the 590 tonne per day scenario, that we unreasonably assumed that PLI would concede payment extensions to claimant and lend additional funds of $13 million, despite claimant's continued refusal to obtain and maintain its social license to operate. And lastly, that claimant's attempt to raise $1 million 5 months before the valuation date was undersubscribed and yielded less than 5% of the early termination amount. Responding to these issues in turn, we note that Ms. Dufour's position is more nuanced than reported in the second AlixPartners report. In her report, she appears to refer to two conclusions: a optimistic scenario of December 2019 and a conservative scenario of July 2020. However, we do understand that the issue of production start date is disputed between the parties, and to assist the tribunal, we show later in this presentation the monthly impact of delaying the start of production in both scenarios. Contrary to AlixPartners' representations, the MICON report does explain how third-party processing issues would have been resolved. To ensure adequate processing capacity, MICON model a 3-month ramp-up in production, and they ultimately conclude that, absent the blockade, Lupaka would have been able to produce the ore tonnages and grades required to service the PLI facility. Now, in relation to the 14 defaults under the PLI loan, claimant's position is that these defaults either directly resulted from a blockade or were related to reporting requirements with which Lupaka complied, or, lastly, were waived. We note that the alleged defaults were raised for the first time in July 2019, when Lonely Mountain acquired Pandian's interest in the PLI loan, at which point claimant had not had access to the site for over 8 months. So thinking now about the but-for situation, we note that the draft third amendment to the PLI loan included an updated indicative gold delivery schedule, with the first delivery due in September 2019. We understand that the operative terms were that the first delivery would be due 9 months after the closure of the Malay acquisition, community approval for which was received in March 2019. Based on this date, the first delivery under the third amendment would have been January 2020, which is within the range of Ms. Dufour's possible production start dates. And I think it's important to note here that the possibility of delays to the effective start date of the third amendment and the consequences on the delivery schedule were foreseen by Pandian in October 2018. And immediately prior to the blockade, Pandian was therefore contemplating tripling its exposure to the Invicta project from $7 million to $20 million, while delaying the date of first repayment to September 2019 at the earliest, and acknowledging the possibility of further delays. And to us, this appears consistent with evidence of Pandian's previous flexibility set out in Mr. Ellis's witness statement. Lastly, AlixPartners claimed that following their assumed default on the PLI loan, claimant wouldn't have been able to raise financing to settle the early termination amount, citing claimant's undersubscribed equity placement in March 2019. In doing so, AlixPartners ignore the adverse impact of the blockade and claimant's lack of physical possession of the Invicta project on its ability to raise financing. And we note that the fundraisings prior to the blockade were either fully or oversubscribed.
Turning now to our assessment at the valuation date. Now, as I said before, our assessment is based on the work of MICON, the technical mining experts, and they were instructed to do a number of things, including ascertain the validity of the Red Cloud model, adjust the PEA production and cost schedules to reflect the actual situation at the mine in October 2018, and opine on Lupaka's ability to meet its obligations under the PLI loan, and explain variances in pre-production grades achieved at third-party toll processors. And when it comes down to it, the disagreements between Accuracy and Alex Partners largely relate to two areas. Firstly, Mycon's inputs, and secondly, our Accuracy's discount rate assumptions. So quickly on Mycon, for the 590 ton day scenario, as compared to the Red Cloud model, Mycon updated its mine plan, started production in November 2018, and applied higher operating costs and capital expenditure. Similarly, in the 355 ton day scenario, they started production in November 2018 and also applied higher operating costs and adjusted the capital expenditure. Now, Alex Partners have a number of comments on Mycon's inputs. Clearly, they haven't been called to give evidence to the tribunal this week. What we've tried to do is point in the Appendix B, point the tribunal to answers to Alex Partners' questions, which are already in the Mycon report and in other evidence submitted in these proceedings. First of all, I want to just pick up on the comments of my colleague about the fact that the tribunal may consider that the project start date needs to be adjusted. That's a dispute between the parties, obviously, and also a cost of an agreement with the Paran community. The tribunal may think it appropriate to do so. Again, that's disputed between the parties. But to assist, we've assessed the delay of the start of a production to be, on average, $500,000 per month in the higher scenario, and $250,000 per month in the lower scenario. Including the cost of maintaining an agreement with Paran, we've calculated that on a similar basis to the deals that were done with other communities. And after tax, this would decrease damages by US dollars 1.6 million in the higher scenario and US dollars 1.2 million in the lower scenario. I just want to give an example, though, of one of the disagreements from Alex Partners. I mean, Alex Partners consider that the 10-year mine plan in Mycon's 590 ton per day scenario to be unreasonable. And then they come in and they propose a sensitivity where they simply lop off the last 3 years of that mine plan. Now, of course, you don't need to be a technical mining expert to say, well, if you're going to reduce the life of the mine and the mine plan, then you just don't lop off the last 3 years. You change the plan. You look at taking the highest grade material from the mine, and you do that at a lower capital expenditure. So it changes the economics. And so that sort of brutal adjustment is inappropriate. As I said, there are a number of other areas, but I won't dwell on those. We've given pointers in the appendix to the presentation as to where the tribunal might find the evidence in the Mycon report to respond to the other questions. Now, turning to our own inputs, on top of Mycon inputs in both scenarios, we make assumptions for metal prices, financing cash flows, working capital requirements, and taxation. Our understanding is that Alex Partners agree with the way in which we apply these assumptions. The area where they disagree is the discount rate. What have we done? We've obtained the fair market value. To do so, we discount the resulting free cash flows to equity back to the valuation date using an estimate of the cost of equity for a hypothetical gold mining entity operating in Peru. We applied a real discount rate of 12.2%, can be broken down between the real cost of equity of 8.9% and a pre-production premium of 3.3%, which is based on independent industry studies to reflect the stage of development of the Invicta project and the associated risks. Now, Alex Partners say, well, this study you've come up with on pre-production premiums is too old. It dates back a few years, but there's no reason to believe that the findings have changed. And, of course, Alex Partners don't propose any alternative. They go on to say, well, if we're going to use that study, we should be using a premium of 5.7% instead of 3.3%. Because they say that the 3.3% is applicable to mining projects that have undergone feasibility studies, whereas in this case the PEA is akin to a pre-feasibility study. But of course that's a very narrow view. You've got to look at the context of this case. And given that a feasibility study is there to raise financing, this case, the project had already received third-party financing, and they progressed it to an extent where it was close to entering into production. So in fact, you can argue that the position of this project was more advanced stage than some projects at the feasibility study stage. It's for that reason we are comfortable with the pre-production premium of 3.3%. They also consider that our discount rate does not reflect risks relating to obtaining relevant permits. Secondly, project-specific social license risk. And thirdly, execution risks such as third-party processing issues. We consider that the project-specific risks are sufficiently accounted for through the premiums applied to our discount rate and the assumptions underlying the cash flow projections. Indeed, our country risk premium reduces our valuation by 3 million under the higher scenario, and our pre-production premium by $6 million US, also under the higher production scenario. Indeed, the last point is on the fair market value standard, any claimant-specific risks should not be taken into account. So I understood that there was some disagreement as to the effectiveness of the community relations team. Those are claimant-specific, and in determining the value under the fair market value standard should not be taken into account.
Turning now to benchmarking, we sought to benchmark our DCF valuations against 3 alternative indicators of value: claimant's market capitalization, claimant's sunk costs, and transactions in comparable gold properties. So, market capitalization is recognized by SimVal as a secondary valuation technique. And as you can see from the chart on the bottom of the slide, from January 2013 to the blockade date, there was broad correlation between claimant share price, which is the blue line, and the GDXJ, which is an index of junior gold mining companies represented by the yellow line. However, following the blockade, there was a marked decline in claimant share price, which diverged significantly from the GDXJ. And this suggests that claimant share price was negatively affected by the alleged breaches. Now, in their first report, Alex Partners noted that claimant's market capitalization appears to have underperformed the GDXJ between 28th of March 2018, when its option on the Josny Toro project lapsed, and the blockade date. And you can see that by the decline in the blue line just before the vertical dotted line. However, we note that the underperformance was immediately preceded by offsetting overperformance, and that the blue line ends up in the same place as the yellow line. So in order to estimate Lupaka's market capitalization in the but-for situation at the valuation date, 26th of August 2019, we applied the movement in the Junior Gold Miner Index between the blockade and valuation dates to claimant's market capitalization as at the blockade date. Now, this is a recognized approach. We then added a control premium to reflect the additional consideration that a hypothetical investor would pay to own a controlling interest in a company or project, and this resulted in an illustrative valuation of the Invicta project at the valuation date of $32.8 million. I think it's important to note here that as the market was unaware of the proposed Malay acquisition and the draft PLI loan amendment, this is a more appropriate benchmark to our valuation under the 355 tonne per day scenario. Alex Partners argue that daily changes in the index demonstrate a weak relationship with daily movements in Lupaka's share price, and using the relationship based on the correlation of monthly changes instead, they calculate reductions of up to $500,000 to our valuation. Notwithstanding the point that the purpose of our analysis is to estimate how claimant's share price would have performed over a 10-month period absent the alleged breaches, and not to predict daily changes, this alternative calculation doesn't move the needle. They further argue that our control premium was not applicable, and that our assessment of the control premium was, in any event, overstated. We disagree. The control premium we applied was an objective average based on 2 studies of observed transactions in the mining industry. And again, applying a control premium to quoted share prices based on observed transactions is standard practice. We further benchmark our damages assessment against an indicator of value based on claimant's sunk costs by firstly identifying costs incurred by claimant in relation to its investment up to the valuation date, including both the acquisition cost and the subsequent expenditure, to which we applied an expected rate of return from the date the costs were incurred to the valuation date. We applied an expected rate of return of 12%, which corresponds to the post-tax effective interest rate on the PLI loan. And after adjusting for the early termination amount, this results in a benchmark value of $27.2 million.
Let me interrupt you for a moment. You have less than 5 minutes remaining, so you may want to consider how you want to proceed.
Thank you. I'll speed up. So according to AlixPartners, under Simval guidelines, the cost approach is not appropriate for the valuation of development properties. We agree that's what Simval says. However, we only use sunk costs as a benchmark, and we consider the sunk cost to be indicative of the minimum value of the project as at the valuation date. They further argue that our application of claimant's borrowing rate of 12% to capitalise sunk costs is inappropriate. However, we consider it to be conservative when compared to our adjustment for the early termination amount, which also includes the cost of upside participation, and we note that capitalising at a rate of less than 12% assumes that claimant would have made returns below its cost of debt. Our calculation implies a value to cost multiple of 1.74 times, which is conservative in comparison to mining industry practice, which recommends a multiple of 3 times for properties at a similar stage to Invicta. And again, this is a recognised approach under Simval guidelines, and applying a 3 times multiple to claimant's sunk costs would result in an illustrative valuation of $58.5 million. Lastly, on transaction multiples, we identified 26 transactions meeting the criteria set out on the page, which resulted in a median equity value multiple of $219 per ounce and a mean of $368 per ounce. I think it's important to note that our analysis demonstrated a positive correlation between gold grade and the gold reserves multiple, and that can be seen on the chart below. After adjusting for the pre-production premium in our DCF valuation to ensure comparability with our sample, which included some producing properties, we obtain an implied multiple for the Invicta project of $198 per ounce under the lower scenario and $144 per ounce under the higher production scenario. Those are indicated by the red dots on the chart below. And we consider that given the comparatively higher grade of the Invicta project compared to recent industry transactions, our DCF valuation is conservative. So AlixPartners' main criticism is that our transaction multiples analysis includes companies that aren't comparable, and they calculate benchmarks using 3 different sets limited to pre-production companies only. One of these sets calculates an implied valuation of circa $22 million under the 355 tonne per day scenario, and circa $42 million under the 590 tonne per day scenario. So there is overlap between the benchmarks calculated by AlixPartners and our valuation of the 590 tonne per day scenario. And we note again that all of the transactions within AlixPartners benchmark sets had a lower grade than the Invicta project, and AlixPartners did not respond to our analysis demonstrating the correlation between grade and multiple. And lastly, we note that Lupaka already had financing in place for the 355 tonne per day scenario, and this may not have been the case for pre-production properties within our sample. And on this slide, we set out the results of our benchmarking analysis, which shows that our assessments are either in line with or conservative as compared to the benchmarks, whereas Alex Partners' assessments, and in particular their alternative valuation of the 590 tonne per day scenario using DCF in the bottom right, appears understated.
45 seconds to wrap up, Mr. President. Just on pre-award interest, in Accuracy 2, we were instructed to apply pre-award interest using alternative rates of LIBOR plus 4 and USD plus 5. By contrast, Alex Partners present the pre-award interest calculation using different rates, USD plus 2 and SOFR plus 2, and they say those are reasonable alternatives. But in our view, the rates proposed by Alex Partners are inappropriate, as they result in cumulative rates below inflation. And what this means is that the value of an award to claimant would decline in real terms with the passage of time. That doesn't seem reasonable to us. Indeed, UST and SOFR are risk-free rates, and you would need to apply a spread to those to equate to LIBOR.
Sir, with that, your time has expired.
I've just 10 seconds.
15, take 15.
15, okay. Well then, in summary, having applied interest, damages including pre-award interest amount to between 38.5 million and 50.4 million US dollars, depending on the production scenario and the interest rate applied. Thank you very much for your attention, members of the tribunal. That concludes our presentation.
Thank you, gentlemen. Over to counsel for the respondent.
My colleague, Mr. Bombasaro, will conduct the cross-examination.
Good morning, Mr. Dovenvorda and Mr. Richards. My name is Brian Bombasaro, and I will be asking you questions about the two reports you submitted in this arbitration. Those two reports should be in front of you, along with a binder of documents, to which I'll refer as we proceed. Do you have your two reports and the binder?
Yes. Thank you.
As I ask questions, I may refer to the initial transcripts of the past hearing days whose pagination could change due to eventual corrections. Any transcript references I make today will be to the pages of the initial transcripts that we have received. In your first report, will you please turn to page 28? And paragraph 4.6. In that paragraph, you define fair market value to mean the price expressed in cash or equivalents at which an asset would change hands between a hypothetical buyer and seller, acting at arm's length in an open market where the parties are knowledgeable, informed, prudent, and under no compulsion to transact. Last Monday, the tribunal asked 2 questions to claimant's counsel regarding your fair market value valuations, and I would like to check if you agree with counsel's answer. As recorded in Monday's transcript at page 167, the tribunal asked whether the hypothetical, well-informed purchaser of Invicta, quote, would be able to carry forward the business free of any social disruption, unquote, and whether, quote, the premise is that Peru would, going forward in the future, do whatever is required, whenever is required, to assure that result. Is that the premise, unquote? Claimant's counsel responded, yes, that's the premise. Let me ask you, did the tribunal state correctly the premise of your damages calculations?
I think we're obviously assessing damages under claimant's case, which is that the intervention by Peru would have resolved the blockade. I think it's beyond our expertise to say what the outcome of the social issues would have been.
If the tribunal were to instruct you to process into your valuations a new assumption that on the valuation date, the entire Peron community voluntarily relocated itself 1,000 kilometers away to live there permanently and never again approach the Invicta mine, which elements of your valuations would you change?
I mean, from our perspective, that would obviously de-risk the project. It would reduce the social license risk. So we would probably consider an adjustment to the cash flows to remove some of the social costs. We could consider a reduction to the discount rate to remove some of the pre-production premium and some of the country risk premium.
And so you're indicating that you have processed social license risk into your valuations?
The risk of social license is already incorporated into our valuation in general terms. So under the fair market value, we're talking about an investor, hypothetical investor if you like, investing in a gold mine in Peru. And in order to evaluate that risk, he takes that into account in his either discount rate when he's assessing the value, or in his cash flows. Now there are elements in the discount rate which take into account the social license risk. It can be in the beta, which relates to a mining industry in general. It could be in the country risk premium, which sets out the risk relating to doing business in Peru, and also that hypothetical purchaser, as we have done, provided a pre-production premium, which also would take into account the risks in general, but also the risks relating to social license, on the basis that at that stage of the development, the risk of needing to do so was higher than if the agreements had already been reached and the project had gone into production. The other hand of that is that you can also take risk into account in your cash flows. And of course, if we look at this case in determining the fair market value, risk has been taken into account in the cash flows in the form of the estimated payments to the communities, reflecting the agreements with Laxanga and Santo Domingo. And so the hypothetical purchase taken into the risk where he can in the cash flows, as well as in the discount rate. And in fact, there may be some duplication there. The question here is, to what extent does risk need to be taken into account for the Paran community, for example? Now, in general, that risk is taken into account in the discount rate, because that's generally a risk that an investor faces when investing in a mining project in Peru. But the question for the tribunal is, well, should additional costs be incorporated into the assessment of damages for the Paran community? Now, at that stage, we can't help because that's a matter that's disputed between the parties. All we can do is say, tribunal, if you think that you need to incorporate extra costs into those cash flows to deal with the risk, then we have given the opportunity for the tribunal to do so by quantifying that as a sensitivity.
Thank you, Mr. Dovenvoorde. Just to remind you, we're on a time limit, and so I just kindly request succinct answers to the questions. Could you please turn to your second report, page 69? On this page, paragraph 7.43 states that you estimate the annual nominal effective interest rate on the PLI loan to be 17.0% pre-tax and 12.0% post-tax. Do either of those loan interest rates account for expected payments of upside participation under the PLI loan?
No, they don't.
If you had included expected payments of upside participation in your calculation, would the annual effective interest rate on the PLI loan have been higher than 17.0% pre-tax and 12.0% post-tax?
Yes.
Still in your second report, please turn to page 43. In footnote 163, you state that you calculated an effective interest rate of 16.1% nominal.
Sorry, counsel.
Yes.
Just give me time to find the page, and
I'm sorry.
that will be very helpful. Thank you.
The pages are also being displayed on the screens as well. In footnote 163, you state that you calculated an effective interest rate of 16.1% nominal pre-tax in your 590 tons per day scenario. This 590 scenario includes the PLI loan plus the draft third amendment. Is that correct?
Yes.
Does this 16.1% interest rate account for expected payments of upside participation under the PLI loan and draft third amendment?
No, it does not.
If you had included expected payments of upside participation in your calculation here, would the annual effective interest rate on the PLI loan and draft third amendment be higher than 16.1%?
Yes, it would have.
Excuse me, would you please explain or remind us what upside participation is? Briefly, please.
Yeah, thank you for the question. So upside participation is whereby the lender would benefit in part from an increase in gold prices above a predefined level. So they had these payment obligations, delivery obligations, where the lender would be able to buy the ounces at market prices less a discount of $500. And that was how Lupaka was going to make its repayments under the PLI loan. The deemed value of those repayments was $500 per ounce. And then on top of that, there was an additional upside for the lender, whereby I think they got 30% of the gold price above a certain value, a threshold value.
Thank you.
Still in your second report, please turn to paragraph 5.25. In that paragraph, you mentioned that your valuations apply a cost of equity of 12.2%. Paragraph 525 states that this 12.2% cost of equity is not comparable to the PLI loan's 17.0% pre-tax annual effective interest rate because, among other reasons, the PLI loan's interest rate is, quote, claimant specific, unquote, whereas your cost of equity applies only to a, quote, hypothetical gold mining entity in Peru, unquote. what does it mean for your cost of equity to apply only to a hypothetical gold mining entity in Peru rather than being claimant specific?
Well, it means we've calculated it using the capital asset pricing model. So it's based on the returns required by an average market participant investing in the mining sector in Peru before we apply our premiums, our additional pre-production premium.
So when you say it's based on the returns required by an average market participant, does that mean your cost of equity applies specifically to an average or typical gold mining entity in Peru rather than any hypothetical gold mining entity in Peru?
I mean, before we apply the pre-production premium, yes.
And in your reports, is it correct that your valuations are not of a hypothetical gold mining entity in Peru, but rather they are valuations of one particular mining entity in Peru, namely the Invicta Mining Corporation?
Yes, but it represents, under the fair market standard, a transaction between a hypothetical seller and a hypothetical purchaser.
And is it correct that in each of your valuations you used your discount rate as the cost of equity?
Yes.
In your second report, will you please turn to paragraph 5.18? In this paragraph, you state that you updated the modeling in your first report to instead assume that, quote, a prospective purchaser would have acquired the Invicta project with the PLI loan in place, unquote. When you say the prospective purchaser, are you referring to the hypothetical buyer in your definition of fair market value?
Yes.
Are you contemplating then that the prospective purchaser is not just any hypothetical buyer of the Invicta shares, but rather it is a buyer who is willing both to purchase the Invicta shares and also to undertake claimant's payment obligations under the PLI loan?
Yeah, it's a question of at the valuation date in August. In August 2019, the transaction for Melee, for example, would have occurred because that was due to occur in a but for situation in March. And so that debt would be in place. So even if the hypothetical purchaser came in and using his own financing through his discount rate, he would have two options. In fact, we've chosen the most prudent option in terms of how to deal with the financing that was in place at the valuation date, by assuming that financing would stay in place and would be supported by future cash flows until extinction.
Does your valuation account for a narrower pool of hypothetical buyers, if any exist, who not only want to purchase the Invicta shares, but who are also willing to assume claimant's payment obligations under the PLI loan?
I mean, I don't know if I quite see it that way. I think obviously we conducted our valuation using the fair market value standard. We also had to give consideration to the principle of full reparation and the facts on the record. And the facts on the record showed that claimant was contemplating funding the acquisition of the Malay plant using the PLI loan, and the amendment to the PLI loan. The PLI had already advanced funds to claimant. So it seemed, and I think it was one of the criticisms that Alex Partners made of how we'd modeled financing in our first report, that we didn't take into account the terms of the PLI loan. So we were trying to reduce the areas of disagreement between the experts by modelling the PLI loan directly in the cash flows in our second report.
Were you instructed to estimate damages based on the fair market value valuation?
Yes, as we said in our presentation.
And Mr. Richards, when you said you also took reference to the principle of full reparation, does that mean that you estimated damages based on the different concept of investment value?
No, it does not.
Regarding interest rates, are daily quotes of SOFR, dollar LIBOR, and 1-year U.S. Treasury interest rates, each market determined?
Sorry, is that a question?
Yes, the question is, are
Forgive me, could you repeat
That's
the
okay.
question?
Yeah. Are daily quotes of the SOFR, dollar LIBOR, and 1-year U.S. Treasury interest rates each market determined?
They are market determined, but they're not comparable to LIBOR.
Are daily quotes of SOFR, dollar LIBOR, and 1-year U.S. Treasury interest rates fixed interest rates or variable interest rates?
They're variable, but the difference.
Go ahead.
Sorry, I was just going to explain for the benefit of the tribunal that first of all, UST is a risk-free rate because it's based on Treasury bills, U.S. Treasury bills.
If I may interject, your claimant's counsel will have an opportunity on redirect to ask you questions beyond the scope of my questions.
I'm simply trying to make my responses as informative for the tribunal as possible.
I
As
think while the tribunal appreciates that, still, I would encourage you to respond precisely to the question that was asked.
As variable interest rates, do SOFR, dollar LIBOR, and 1-year U.S. Treasury interest rates each respond to prevailing economic conditions?
In general, yes.
Among the economic conditions that those interest rates respond to, would you include changes in interest rate policies set by the United States Federal Reserve?
Yes.
And is it your understanding that among the United States Federal Reserve mandates is a mandate to apply interest rate policies to foster low and stable inflation?
I'm not sure I'm in a position to comment on U.S. government policy.
I'd like to return to the concept of fair market value in your first report in paragraph 4.6. As we discussed earlier, fair market value contemplates a hypothetical buyer and seller with certain attributes transacting in certain circumstances. All else equal, does the seller always prefer to receive a higher price for a given asset?
Yes.
And all else equal, does the buyer always prefer to pay a lower price for a given asset?
All else equal, yes.
And all else equal, does the buyer determine its offer price based on the value to the buyer of owning the particular asset?
Yes.
And when the buyer is determining its offer price for the asset, does the buyer take into account any attributes of the seller or only attributes of the asset?
Well, it depends if it's under the fair market value standard or not.
Yes, under the fair market value standard.
So under the fair market value standard, no.
For example, under the fair market value standard, does the hypothetical buyer adjust its offer price depending on the indebtedness of the seller?
No, because you're dealing with a hypothetical buyer and seller, so you wouldn't take into account the attributes of the specific seller.
Thank you. In your first report, please turn to page 14, which is where section 3 of your report begins. On page 14, in paragraph 3.2, you stated that, quote, "In this section, we summarize the facts of the dispute that are relevant to our assessment of damages," unquote. Is that correct?
Yes, that was our intention.
Still in section 3, on page 16, will you please turn to and review paragraphs 3.10 and 3.11? In these two paragraphs, you discuss certain mine authorizations and permits and an environmental impact assessment. Why did you consider these facts to be facts relevant to your damages assessment?
I mean, it's really just part of the general background. I mean, I wouldn't say that we had relied on these. I think when you lead into paragraph 311, we understood from claimant that the development works had been materially completed, and that was relevant for how we did adjusted the capex that was included in the first year in the PEA mine plan.
Paragraphs 3.10 and 3.11 include citations to claimant's request for arbitration, specifically paragraphs 14, 18, and 19. Did you review all of the paragraphs numbered from 14 to 19 in claimant's request for arbitration?
I have to say, I personally don't recall reviewing all those paragraphs, but I would highlight paragraph 3.3. This is background to the dispute, so it's not relating to our expertise. It's background. The summary, as we say in 3.3, is not intended to be contentious, nor is it intended to be an exhaustive description of all matters relating to the dispute. And we say some of which obviously fall outside the scope of our instructions, or which we may not be aware of.
So, as you stated, my understanding correctly, paragraph 3.3 states that this summary is not intended to be an exhaustive description of all matters relating to the dispute, but paragraph 3.2 says that we summarize the facts of the dispute that are relevant to our assessment of damages. Am I reading that correctly?
Yes.
Claimant's request for arbitration is in your binder in tab 30. Will you please open it and turn to paragraph 15?
Sorry, which tab?
Tab 30, 30. This paragraph 15 and footnote 13 indicate that claimant's mining plan was approved through resolution number 0566-2014. Is that correct? Footnote 13.
Yes, that's what it says.
Resolution 0566-2014 is in Exhibit C9 in tab 2. Could you please turn to Exhibit C9? For the record, in this Exhibit C9, the top right corner says C9 corrected translation, and it includes the original version of this document in Spanish. Please turn to page 10 of this exhibit. Page 10 has a bold underlined header that says resolution.
Sorry, could you?
I'm sorry.
Can I get there first before you ask the question? Thanks.
It's the final page of the document in your binder. Not in the printed version of the binder, but in the record, claimant did submit the original Spanish in Exhibit C10. C9, I'm sorry. The top of page 10 has a bold underlined header that says resolution number 0566-2014. And the first sentence of the resolution states that, quote, having seen the above report and agreeing with the opinion of the Mining Technical Directorate, approve the mining plan of the Invicta mining project to carry out mining activities with a capacity of 400 tons per day presented by Invicta Mining Corp. According to the first sentence of this resolution, was Invicta Mining Corporation approved to carry out mining activities with a capacity of 400 tons per day?
Yes.
In your first report, did you include in section 3 as a fact relevant to your damages assessment that Invicta was improved for mining at a capacity of 400 tons per day?
No, we did not. I don't think we were aware of this at the time. We hadn't looked at the underlying exhibit.
Are any of your valuations premised on mining activities that would exceed 400 tons per day?
Yes, obviously the 590 ton per day scenario is premised on a capacity of greater than 400 tons per day. But if I understand correctly, Invicta had initially planned a much larger scale operation, I think 5,000 tons per day, and this application for a capacity of 400 tons per day was a reduction. They were applying, in effect, for a reduction of their initial license capacity. While it's outside of my expertise, I think as a layperson, I don't see that they would have faced great difficulties in getting a license for 590 tons per day.
In the first line of that same resolution in Exhibit C9, where the resolution says approve in bold capital letters, does it state that the resolution is approving, quote, the mining plan of Invicta Mining Corporation?
Yes, to approve the mining plan of the Invicta mining project, yes.
Did you review the approved mining plan?
No, I did not.
For the record, the mining plan that claimant submitted to MINEM was subject to certain modifications that are summarized in the first 9 pages of this Exhibit C9, which appear to be stated in full in Exhibit MD 86, which is in tab 29. The mining plan that claimant initially submitted is in Exhibit C41. Will you please open that Exhibit C41 in tab 3? In Exhibit C41 in tab 3, please turn to the last page, which is page 119. Do you see the title on this page as stating Chapter 11, Schedule of Activities?
Yes.
In this schedule, the leftmost column lists 6 activities: explorations, preparations and development, exploitation, progressive closure, final closing, and maintenance and post-closure monitoring. According to this schedule, which is part of the mining plan that MINEM approved, in which years does exploitation occur?
With respect, Council, I think these are questions concerning the mine plan and should really be addressed to the technical mining expert, Micon. I'm not sure we're comfortable about responding to these questions. I think they're outside of our expertise.
Council, can't we read that for ourselves? I mean, we've got these documents which say what they say. Why ask the witness, do they say what they say? You've done this about 6-7 times in a row. You can take us the documents, we can see what they say. You don't have to ask the witness whether they say that.
Thank you, Dr. Griffith. In your second report, how many years of exploitations activities do you value in your 590 tons per day scenario?
So where in the second report?
Well, anywhere in your second report, do you recall how many years of exploitation activities you provided for in your 590 tons per day production scenario?
I mean, once again, the mine plan was developed by the technical mining expert in terms of the life of the mine plan. You know, we can cite the length of the periods and all that sort of thing, but the questions as to why it was done that way, the assumptions upon which it was done that way, they're not questions for us really, they're questions for the technical mining expert.
Did I ask any questions about why the assumptions were in the parameters they were, why they were? I'm just asking if you identified them.
You're asking a question about the life of the mine under the mine plan.
I'm asking about what is stated in the mining report on page 119, the mining plan that was approved by MINEM.
So I don't understand the question, and I'm not sure it's within our expertise
I can answer that
too.
question because it says it's years 2, 3, 4, 5, 6, and 7. So do you need the witness to answer that?
Thank you, Dr. Griffith. In your second report, could you please turn to paragraph 643? This paragraph mentions the assumptions that you adopted from Micon for the start date and ramp-up period for commercial exploitation. It states that, consistent with the approach taken in the 590 tons per day scenario, in order to ensure availability of adequate toll processing capacity, Micon assume a start date for production in November 2018, starting at 100 tons per day, and ramping up to steady state production of 355 tons per day using third-party toll processors by February 2019. Could you please turn to paragraph 3.25D? May I implore the tribunal for a short break?
Of course, we're scheduled for a 10-minute break in 20 minutes. Your wish is for something shorter than that, or do you want the 10-minute break?
10 minutes would be fine.
So you want us to have the scheduled 10-minute break 20 minutes earlier?
Please, yes.
All right. Then we will rise for 10 minutes. Are we ready to resume? All right, we will, I think that was an affirmative, okay. All right, let's resume the cross-examination of the experts then.
Thank you. Is it your understanding that Pandian eventually sold PLI Wauda to Lonely Mountain?
Yes.
In the transcript from last Monday on page 121, claimant's counsel suggested that Pandian sold PLI Wauda to Lonely Mountain for, quote, pennies on the dollar, unquote. Are you aware of any evidence of the exact or approximate price that Lonely Mountain paid to Pandian to purchase PLI Wauda?
I think there's a technical issue with the exhibits. Were you trying to take me to anything to the transcript or not? Okay.
No, I'm just asking your recollection.
No, I'm not aware.
Okay. Last Monday, claimant's counsel also suggested that PLI Wauda would abstain from enforcing its rights under the PPF agreement because the agreement was a, quote, lucrative gold streaming loan. That's on page 120 of the transcript. In your second report, you valued the so-called gold streams, which you refer to as PLI Wauda's upside participation, on page 83 in paragraphs A213 and A217. If we can go to paragraph A213 first, please. Okay. Paragraph A213 states that you, quote, estimate total upside participation to be $6.7 million in the 355 tons per day scenario. When you say the sum is a total estimate, does that mean that you did not discount the upside participation payments totaling $6.7 million to their net present value as of the valuation date?
I can't recall whether that 6.7 million number is before or after discounting.
And similarly, in paragraph 2.17, you state that you, quote, estimate total upside participation to be $9.9 million in the 590 tons per day scenario. Do you recall whether this figure would have been discounted to net present value as of the valuation date?
We have the same response to that. What I would add is that in Alex Partners' report, they agree with the way we apply the financing. So I'm not sure what's subject to dispute here.
Just trying to understand the paragraphs. And would you kindly remind the tribunal what the term upside participation means specifically? What is the upside, who participates, and by what means?
So the upside participation is whereby the lender gets to share in the benefits to Lupaka if the gold price goes above a certain threshold level. And I think I touched on this earlier, and it looks like my recollection was broadly correct, and you can see it at paragraphs A29 and A210, I think just on the previous page.
Thank you. If the lender, PLI Wauda in this case, in its business judgment, considered that over time, claimant was becoming increasingly unlikely to operate the Invicta mine according to the mining plan, would PLI Wauda be rational to reduce its valuation of its upside participation in the PPF agreement?
I don't know whether it's a question of rational or not, but I think obviously it's something that they would model, and they did have detailed models. We know they were exchanging emails with claimants and updating their models based on, for example, the prospective Malay acquisition. But obviously if you delay production, if you delay repayment significantly, then the present value of the upside participation to Pandian would be reduced.
If PLI Wauda were to seize the Invicta shares, are you aware of any reason why PLI Wauda could not resell those shares for fair market value?
Yes, because it follows a foreclosure, and so that foreclosure would be in the public domain, and therefore it would be viewed as a distress sale, and therefore you'd be using a different valuation standard in respect of that, not the fair market value.
Is it correct that the value of the shares to PLI Wauda would not be limited or affected by PLI Wauda's ability or inability to conduct mining operations?
Yes, I think that's correct, but I think the big factor here was obviously the blockade and whether anyone could have actually physically had access to this mine.
If PLI were to foreclose on the Invicta shares and resell them, are you aware of any reason why PLI could not retain a portion of the shares for itself, for instance, as a minority shareholder?
I'm not aware of any reason, no.
And if PLI were to foreclose on the Invicta shares and resell them, are you aware of any reason why PLI Wauda could not sell the shares subject to having for itself upside participation in Invicta's subsequent operations under a new owner?
Again, I'm not aware of any restriction.
I'd like to briefly show you 3 emails among members of claimants management from July, August, and September 2018 before the Access Road protest, where they comment on the company's financial situation. Could you please turn first to Exhibit R217 at tab 25? This first email is dated 28 July 2018 and includes a note from claimants management that, quote, the mine needs to produce a minimum of 6,000 tons of mineral each month so that sufficient concentrates will be produced and sold to cover cost. Am I correct that 6,000 tons per month corresponds to approximately 200 tons per day?
Yes.
Okay. And if you could turn to Exhibit R215 at tab 26. On page 3, the email states, cash forecast from 3 August 2018 indicated that Invicta needed 7,000 tons to break even based on monthly expenditures. Am I correct that 7,000 tons corresponds to approximately 233 tons per month, assuming they're referring to 7,000 tons per month?
Sorry, counsel, I shouldn't do this, but this is just arithmetic that's being put to this witness. And when you say 200 tons a day, that's assuming a one shift for 5 days. So where does this get us?
Well, in general, the references to the production rate in this case have been stated in terms of tons per day rather than tons per month. So I just want to translate the rate and ensure they agree with the arithmetic. Finally, could you please turn to tab C421 at tab 20? On page 3, the message notes that Invicta was, quote, at the point where it would not be able to pay its contractors and suppliers, unquote. Under the heading mining/mining license.
I found it, thanks.
Did you inspect any cash flow records of Invicta Mining Corporation from the years 2018 or 2019 in preparing your valuations?
Yeah, I think we reviewed the financial statements generally in preparing our sunk cost analysis. but I don't recall looking at specifically at cash flows in 2018 and 2019.
When you say you reviewed the financial statements, were those specifically of Invicta Mining Corporation or Lupaka Gold Corporation?
Lupaka Gold Corp.
Thank you. Regarding sunk costs, in your reports, am I correct that one of your other indicators of value is sunk costs?
Yes.
And as a general proposition, is it true that a value of a business can decline to be lower than the amount of sunk costs that were invested in the business?
As a general proposition, yes.
Thank you. Do you recall a comment from Alex Partners concerning a discrepancy between the gold ore grade reported in Invicta's records from its actual operation of the mine versus the budgeted ore grade that Invicta Mining Corporation had contemplated?
Yes.
And do you understand Alex Partners to have raised that issue as casting doubt on whether the ore grade, the gold ore grade, assumed in your valuations was the appropriate ore grade, gold ore grade to apply?
Yeah, I think so, yes.
If I asked you to process into your valuations an assumption that Invicta was 100% certain to achieve the ore grades contemplated in your valuations, would you make any changes to those valuations?
So in effect, you're asking me to assume that the cash flows are certain?
Not the cash flows, but the gold ore grade achieved from commercial mining operations.
I mean, I think I'd have to discuss that with the technical mining expert to work out how that compares to what they've used for their cash flows currently.
If I asked you to process into your valuations an assumption that claimant would have no issues or problems using third-party ore processors, that there would be no issues before claimant start date for commercial mining, would you make any changes to your valuations?
Again, I think that's a question for Mike on the technical mining expert. I mean, we know that they took in assumption to ramp up production in both scenarios, to take into account some teething problems at the processing plants. But so, if there were none, then you wouldn't have to potentially ramp up the production. But as I say, this is generally a question it's more appropriate to ask the technical mining experts.
As you understand your damages model, though, is the 3-month ramp-up period the only place that takes account of potential problems using third-party ore processors?
No, of course not. It's in the pre-production premium of 3.3%. Given the stage of development of the mine, that may well cover those sort of potential issues.
And is it correct that your pre-production premium accounts for the average risk encountered by a typical mine that has been subject to a feasibility study?
I think we covered this off in the presentation.
Can you remind me of the answer?
The answer was that there were two pertinent rates. There was a rate of 5.7% pre-production premium, which is stated relates to projects at the feasibility study stage, and then there was a 3.3% rate, which 3.3% relating to the feasibility study stage, and 5.7% for an earlier stage. What we said here, that's the general rule, but you need to look at the context of the case and the position of the company. The position of the company was that it had already raised finance, and that was one of the main things that you generate a feasibility study for, is to go out to the market, use that to generate finance. They didn't need to do that because they had finance in place. The second element was that they were close to production. They were doing pre-production runs. And therefore, in that context, as I said in the presentation, the project was arguably more advanced than certain projects which had been subject to a feasibility study. And it was on that basis that we found it more than reasonable to assume the lower pre-production premium of 3.3%.
Thank you, Mr. Van Duvenvoorde, and thank you, Mr. Edwards. I have no further questions.
All right, over to claimants for any redirect.
Thank you, Mr. President. No redirect.
Let me ask my colleagues if they have any questions. Please.
May I address you collectively as experts?
Of course, sir.
Thank you. Am I incorrect that often it's put that a discounted cash flow approach is inappropriate when there's not an established business?
That's it depends. I think you can't generalise. You need to look at the specific context of the case. But
Well, I'm asking the question because as I read your two reports, you don't admit that as a possibility as a primary method.
so you don't admit.
You don't admit that as a possibility as a primary valuation method for a non-established business.
Yeah, I think in this case there is agreement between Alex Partners and Accuracy that DCF is the appropriate approach. And
Well,
the
maybe,
reason,
but it's a tribunal to decide. I mean, there are other decisions out there which in no way bind us, which indicate where there's no established business, sunk costs is an appropriate methodology. Is that correct?
I understand that there are decisions out there that have decided that sunk costs are appropriate for earlier stage businesses. However, my personal view is that in this case, the DCF methodology is appropriate, because effectively we're dealing with a resource, a property that's in development. So if you look at the SimVal guidelines, it says the income approach is appropriate, and in fact it says the cost approach is not appropriate. And bear in mind what Micon have done. They have done an extremely detailed level of work which shows a 3D map of what was going to be mined over these years, with the grades, with all the little ramps to get between the different levels. It's much more certain than a speculative business plan for a business that hasn't started yet.
Well, would you, as expert, accept the possibility that one can go beyond benchmark and adopt sunk costs as a valuation method where there's not an established business?
It's always possible, but in this particular case, we are guided by SimVal, Canadian Mining Institute for Evaluation of Mines. And clearly they set out the different criteria, the stage of the mine, and the methods that are proposed, which are recommended to be used at each stage of the mine development. And in this case, I don't think there's any dispute between Alex Partners, Accuracy, indeed Micon, that it was at the development stage. And so if you look at the SimVal guidance, one can see that their recommended approach, their primary approach, is indeed a discounted cash flow approach.
Thank you. Nonetheless, would you accept that as a benchmark, as you refer to it, sunk costs gives you a valuation in the same range to the valuation of discounted cash flow that you adopted here?
It's in the same range as our lower valuation under the 355. Yeah. But obviously the 590 tonne per day scenario is more closely aligned with claimant's actual plans for development of the project.
Well, if you adopt the 300 tonne per day approach, would you agree that the sunk cost approach is confirmatory in the range of the amount that you have as your valuation on 300 tonnes per day?
It's in the range, but then so are the other benchmarks, market capitalisation, etc.
Which you can add them all up and see that that's the range. Thank you.
Maybe just for the record, the document, I think the experts were referring to, you find that at AC 22.
Thank you, Council.
Sorry, and if I went to AC 22, is that the SimVal methodology?
Correct.
Okay.
That's a similar methodology, and we saw the table, I think, in the opening statements of the experts, and that's at page 18.
Any further questions? No. In that case, then, gentlemen, we thank you for your assistance. You are now free men.
Thank you very much, Mr. President.
Thank you.
You may be excused. We will now have to sort out some housekeeping as to whether we are in a position to proceed to the next examination. Take guidance from the parties. I see an affirmative nod from claimant. All right.
I'm sorry, Mr. President. This is the court reporter. I need the witnesses' names. I wasn't expecting them so quickly. I thought I'd have a few minutes. Their names, and then I need to make a couple computer entries.
We will have them introduce themselves in just a moment.
Well, could I have that before we are on the record so I could put it in
All
the
right.
computer?
Can the witnesses introduce themselves, please?
Yes, my name is Isabel Santos Kunzman.
My name is Alexander Lee.
Okay.
All right, we'll wait just a moment while
Yeah.
the
Just about a
reporter is-
minute. All right, thank you.
All right, are we ready? Claimants ready? Okay, respondent, reporters ready, interpreters are ready, he said hopefully.
When they're given the floor, I will put it up.
Okay, Ms. Councilman, Mr. Lee, can you, for the record, identify yourself, please?
Yes. My name is Isabel Santos Kunzman.
My name is Alexander Lee.
Okay, welcome. There should be in front of you an expert's declaration. Do you see that?
I do.
Can you each read it out loud, please?
Yes. I solemnly declare upon my honor and conscience that my statement will be in accordance with my sincere belief.
I solemnly declare upon my honor and conscience that my statement will be in accordance with my sincere belief.
Okay, I'm sure that you are, as experts familiar with the procedure. I understand you will be doing a 30-minute introductory report, is that correct?
Yes.
And you will then be examined. If at any time you need to take a break or anything, let us know. We will probably take a short break at sometime around 11:50, but we will let you know when we're nearing that point. Are you comfortable with the procedure?
Yes.
All right then. Well then, let us hear your 30-minute report.
Great. Thank you very much. Okay, this is not working. This is not working. I can just tell you when to turn the slide.
The dreaded words, "This is not working." Are we ready to begin, or are we still standing by?
I believe we're still standing by for
All
the
right.
clicker.
You'll let us know when we're ready. When you're ready.
Okay, we'll let you know when to. Okay, so if you could please turn to the next slide. In this slide, we just present a.
All right. So we will begin your 30 minutes right here.
Okay, thank you. So in this slide, we just present a brief summary of our qualifications. Next slide, please. In this slide, we present the damages that Accuracy calculates in their first and second report under the 590 tons per day scenario, which is the scenario that claimant relies on to claim damages. Accuracy's damages are not based on the fair market value standard, in that they're not based on a hypothetical buyer, but instead a buyer that would have acquired the Invicta project with the PLI loan in place. Originally, they did calculate fair market value since they deducted $15.9 million, as noted by the letter C on the table, to settle the PLI loan, which I believe has also been referred to as PPF, so it is the same thing. Now, however, as we pointed out in our first report, their damages were overstated for many reasons, but one of them was because they were calculating free cash flows to the firm, which includes the values of the shares and the debt. So in order to just calculate the value of the shares, they needed to subtract $13 million for the Malay plant debt implied in their model. Now, in their second report, they now are using the correct measure of cash flows since they subtract the debt payments for the initial loan and for the Malay loan. However, as I mentioned, they are using the incorrect standard of value in that they're not assuming a hypothetical buyer. Next slide, please. Before we get into the details of our opinions, it's important to review the underlying assumptions in accuracies damages calculation for the 590 tons per day scenario in their second report. In this graph, I show in blue the tons of ore that Invicta expected to process in their 2018 budget. In red, I show the actual tons processed that were dramatically lower. In green bars, I show the tons that accuracy projects Invicta would produce in their 590 scenario between November 2018 and October 2027. I note that in their original first report, they assumed that operations would start in August 2019, the valuation date. But in their second report, they moved it up based on Micon's report to November 2018. Below the graph, I show accuracy's key assumptions. So first, for Invicta to produce, to process this ore, they assume that within 2 weeks, the Peran community conflicts would be solved permanently and at no cost, that a qualified third-party processor would be found, and that the outstanding permits would be obtained. Second, they assume that between December 2018 and March 2019, PLI would have allowed Lupaka to be in default of monthly payments required under the PLI loan Second Amendment, because during that period, that would be the only amendment in force according to their assumptions. Now, third, they assumed that on March 2019, the Malay Plan Agreement would be signed and closed, and the PLI loan Third Amendment signed and closed, and Lupaka would receive $13 million in financing. Finally, they assumed that in September 2019, IMC would obtain permits to transfer to and process ore at the Malay plant, and that IMC would obtain approval to process 590 tons per day for 10 years instead of what had been approved up to that point, which was 400 tons per day for 7 years. Next slide, please. So we now turn to the fundamental flaws in accuracy's damages calculation. And accuracy did a great job of explaining our position, so a lot of this is a bit repetitive. But in the first flaw, we noted that accuracy did not consider that intervention by the police would not have permanently resolved the conflict with the Peran community or the access road protest. Accuracy's underlying assumption is that the conflict with the Peran community would have been immediately and permanently resolved at no additional cost by their start of production date, which would be November 2018. This assumption contradicts Mr. Castañeda's statement that, where he indicated, we knew that the Peran representatives would not be deterred for long, and that once the police had left, the site would again be at risk of invasion. Accuracy dismisses our observation on the grounds that the requirements that may exist under Peruvian law to conclude agreements with local communities are factual issues which fall outside their scope and are not relevant to their assessment of damages under claimant's case. So just to clarify, our opinion is not that that a social license is required from a legal perspective. Our opinion is that obtaining a social license is critical in that you need to acquire the social acceptance from the community to be able to operate your business. So implicit in accuracy's assumption valuation is that the police would need to intervene repeatedly to quell further unrest, as Mr. Castañeda expected. From a valuation perspective, an investment that requires periodic police intervention to operate entails higher risk that should be reflected in the valuation, which could be a combination of delayed cash flows, an interruption of cash flows, higher cost, or an increased discount rate if you do it indirectly. Next slide, please. The second flaw is that accuracy did not consider the remaining social license risk. Social license needs to be managed prior to, during, and after the mining project, and failing to obtain it could lead to project failure. So in the case of Paran, accuracy has not provided evidence to support that claimant would obtain and maintain the social license from November 2018 onward. They also don't take into account that prior to the road blockade, the social licenses with the Laxanga and the Santo Domingo communities were also deteriorating. Next slide, please. Third, accuracy did not consider that claimant would have defaulted on its PLI loan obligations absent the measures under both scenarios due to missing approvals and the ore processing difficulties. With regards to the missing approvals, in this graph I show 3 lines. In red, the payable gold produced actually by Invicta between June and October 2018. Then in green, I show the amount of payable gold required to fulfill the PLI loan agreement, so the second amendment. And in blue, the amount of payable gold required to fulfill the expected draft third amendment to the PLI loan with the delayed Malaya transaction. And when I say expected, that's the assumption that accuracy makes.
If I may, Mr. Chairman, the expert is referring to events or requirements which were struck by you from the Dufour report, or rather than struck, you ruled that you wouldn't consider these additional requirements such as authorization to purchase and store fuel, license to use water from sources not contemplated in the 2009 EIA.
I wonder if the experts are familiar with the tribunal's earlier ruling with respect to elements of Ms. Dufour's report. Have you been briefed on that?
We have, and in this slide we present where we first mentioned these issues in our first report, or that they're mentioned in the counter memorial.
All right. Well, we will allow you to proceed, but with the caveat that we may disregard portions of your report if we conclude that we don't share your assessment that these particular issues were previously raised at a sufficiently early time. Is that understood?
Yeah, I understand.
All right, so be warned.
Thank you. Okay, so then in this graph I also show in a gray bar with the letter C underneath the assumption that, well, the opinion from Mrs. Dufour that at the earliest Invicta would have been able to operate the mine as planned would have been June to July 2020. Next slide, please. Now, with regards to the ore processing issues, MICON provides no basis for their assumption that the failures at the third-party processing plants would be resolved by November 2018. It is also not clear from the MICON or accuracy reports which specific facilities they assume claimant would use for ore processing before Malay. And the contemporaneous evidence indicates that the ore processing issue was a significant issue. So, for example, in an email between Lupaka's management on October 19, 2018, Will Ainsley says, as a result of milling being significantly behind the mine development, I have suspended all development activities. And it's also worthy of note that in September 2018, Invicta was actually considering ceasing all operations until it was feasible to take the ore to the Malay plant. Next slide, please. So typically, the issues that I just mentioned would need to be adjusted for either in the cash flows through a delay or interruption of the cash flows or an increase in cost, or through the discount rate. However, in this case, because of the PLI loan lien on Lupaka's shares in Invicta, if a default occurs, it means that claimant would have to pay a settlement of $15.9 million to make sure they kept ownership of their shares. Otherwise, if you're selling them to a hypothetical buyer under the fair market value standard, the hypothetical buyer would question whether those shares are available for sale or not. Neither claimant nor Accuracy have submitted sufficient evidence to show how claimant would have been able to obtain additional financing to settle the PLI loan agreement. In fact, the contemporaneous evidence shows that prior to the blockade, they were desperately low on funding and had significant funding issues. Next slide, please. So, setting aside the threat of PLI seizure of the Invicta's mine shares, Accuracy discount rate does not account for the risk associated with or fundamental flaws. The Peru country risk premium of 1.4 that they use just takes into account the additional average risk that an investor faces in Peru over the United States. And the pre-production premium only accounts for the level of study of the mineral properties that is scoping pre-feasibility or feasibility study. And as they mentioned earlier today, the social license issues specific to Lupaka, they exclude because they believe those are just associated with the with the seller, not a hypothetical seller. And with that, I will pass on to my colleague.
Next slide, please. So this slide demonstrates our assessment of damages with the assumption that Lupaka would be able to overcome the fundamental flaws discussed by Ms. Kunzman. You can see here we've considered a number of adjustments that we have been able to quantify, as well as ones that we have not been able to quantify due to a lack of information. I had addressed each of these adjustments on the following slides. Next slide. So this first slide compares Accuracy's first report production schedule versus its second report production schedule. In the second report, Accuracy both assumed that production would begin sooner and last longer than its first report, moving the start of production to November 2018 for the first time. We understand, based on the permits that have been outstanding at various points, that November 2018 is not necessarily an acceptable start date, and that by moving the start date to July 2020, consistent with Ms. Dufour's opinion, damages would be reduced by $8.7 million on a standalone basis. Next slide, please. This next slide demonstrates the impact of increasing the life of mine from 7 years to 10 years. You can see here that it's a quite significant part of the value, accounting for about 25% of damages. And if we had limited the production schedule provided to 7 years, that would have a reduction in damages of approximately $10.2 million. Next slide, please. This slide is an attempt that we have made to quantify the cost of obtaining the social license from the Peron community specifically. We used information that was available in the record, including past payments made to the Peron community, the Laxanga community, and the Santo Domingo community. And we're instructed to use scenario 1 here, which is based on the Peron's past requests, as long as an average of the requests made by the or cash payments made to the neighboring communities. That amounts to $300,000 and 300,000 US dollars as a one-time payment and an annual cost of approximately $300,000. Damages are reduced by $2.4 million as a result of this one adjustment. I note that this does not include any additional costs related to some of the unquantified issues that we raised in our report, such as the cost of mitigating any third-party processing issues, the costs to remediate the discrepancy between expected and actual metal grades, and the cost to meet any other regulatory requirements raised by Ms. Dufour. Next slide. Now we turn to the discount rate and specifically Accuracy's pre-production premium. We note in the 590 scenario that the pre-production premium dropped from 6.9% to 3.3% between Accuracy's first and second reports. We note here that the 3.3% is commensurate with a feasibility study level, but that claimant's public disclosures note specifically that there was no feasibility study or pre-feasibility study at that point. Third, we also note that Micon noted in their report that the confidence level of their review only raised the Red Cloud model to that of the 2018 PEA. That's a preliminary economic analysis, which is a lower level of confidence than a pre-feasibility study. While the project may have been at a later stage of development, as suggested by Accuracy, we note that Micon's own reports state that the preliminary economic analysis has a much larger margin for error. There's an error band around preliminary economic analyses that that gets smaller as you go up levels of feasibility study. Making this one adjustment on a standalone basis decreases damages by $3.6 million, but we note that this adjustment cannot account for the fundamental flaws. Next slide, please. This slide highlights some of the inconsistencies that we noted between Accuracy's first and second reports. By virtue of extending the production schedule, Accuracy has added 30% to the production in tonnages, but has only added between 2.4 and 13% to its capex. As I'm sure we're all going to be made aware, we are not qualified mining technical experts. We cannot estimate what the additional capex should be. We just point to this inconsistency as a potential area where additional capex may be required. Next slide, please. This final slide summarizes our adjustments that we have been able to make and quantify, as well as lists a number of adjustments that we have not been able to quantify. As Ms. Kunzman mentioned earlier, ideally we would like to adjust the cash flows to account for any changes or uncertainties, but we've also offered a sensitivity analysis that would allow the tribunal to modify the discount rate, which is a blunter instrument in this case, to increase the discount rate to account for these uncertainties and therefore decrease damages. Next slide. This slide just summarizes the same adjustments that we've made for the 300 tons per day scenario. One thing that we'd note here is that Accuracy did not increase or expand the life of mine in this case. Even though they said that it might be appropriate, they chose not to. So that adjustment is not on this slide. Next slide, please. And this slide also presents the adjustments that we have been able to quantify, notes the ones that we have not been able to quantify, and provides a sensitivity analysis that could be of help to the tribunal. Next slide, please. This slide just is our overview of the other indicators of value that Accuracy provided. We note here that none of those indicators of value can really consider the fundamental flaws because the market metrics that have been used here are disassociated with the flaws and the risks that were present at and around the valuation date. We also noted a number of additional comments that we had in our report and have reference to those sections, but we will not cover them in this presentation. Next slide. And finally, this slide covers our overall position on damages. First, if damages are incorporating the fundamental flaws and they are not overcome, we would consider that damages should be rendered to nil. However, if the tribunal should find that the fundamental flaws are not appropriate to consider, or that Lupaka could overcome those fundamental flaws, the damages should be changed to the numbers per the sensitivity analyses shown here. We've also calculated pre-award interest using the premium that claimant instructed accuracy to use in its first reports. That's 2% over either the SOFR or the UST, and have calculated damages based on those pre-award interest numbers at the bottom of this chart. One last thing that I'd like to note is that Peru has the position that PLI's foreclosure action is not attributable to Peru. If the tribunal were to find that to be the case, we would say that the actual scenario's value of the IMC shares should be increased to match that of PwC's independent valuation of $13.4 million. So that would reduce damages overall, as accuracy assumes that the IMC shares are worth nil, $0 in that case. Thank you.
All right, thank you very much for a succinct and unusually timely report. I think it might, we are scheduled, we anticipate taking about a 5-minute break at some point. I think this might be a good point at which to take it. We can then turn to the examination by claimant's attorney. So let us rise for 5 minutes. logistical question. Are we supposed to have any additional documents in front of us? Here they come. All right. All right, are we ready to begin the examination? Claimants, you ready?
Yes. we are.
Experts, you're ready?
Yes.
Reporter, you're ready? Interpreters are ready? All right, then let us turn to the examination of the experts. Over to you, sir.
Okay, thank you, Mr. President. So, good morning, Ms. Kunzmann. Morning, Mr. Lee. My name is Mark Veit. I'll be asking you some questions. I guess you know the drill. You have been doing this before. So, Ms. Kunzmann, let me take you to your CV, Appendix 1 of your first report. You find it at tab 1. It's page 73 and following of the first report. Now, Ms. Kunzmann, this is the 9th exit case in which you act as an expert appointed by Peru, correct?
I believe it is the 7th, but I have worked on Peru cases where I wasn't the appointed expert, but I was on the team that was working on behalf of Peru.
So you're just working in the background,
Right.
but he still represented Peru, correct?
We were engaged on behalf of Peru, yes. And there's one where we were against.
Yes. So let's go and count them. You say there were 7. I think I counted 9. So
So Gramercy,
Gramercy, that's 1.
Lupaka, well, this one.
Lupaka, this one, yes.
SMM CV, Freeport, that's 4. Lidergon,
Liderkon, 5.
5.
Kuntur Vasi, 6.
Right, so I wasn't the expert on that one. So 5 where I'm the appointed expert, and then where I'm not the appointed expert, Kuntur, the 2 levy cases, and Convial. And then
Yes.
the Duke Energies again. So yeah.
Yes, that's 9.
Yeah, that's 9. What I meant, what I wanted to clarify, that it was 9, but I was only appointed as an expert on a subset of those.
Sure, but you worked on the team that was appointed as expert.
Yes, yes.
And I presume that was in your earlier years acting as expert.
That's right.
Correct. Now,
I have one point for the record. I don't think it matters, but nevertheless, I want to point it out.
Oh, Rango.
One of the cases mentioned here where is it? Tidewater versus Venezuela. Ms. Kuzmas was a junior member of the, I was lead counsel to the claimant in that case. And my client instructed a company of which Ms. Guzman was a junior member. So she participated in that case, but not as testifying expert.
okay.
I'd also like to make a clarification. We forgot to count Renko as well.
Renko?
Exactly. I would have come to that
Yes.
right now.
Yes, I forgot to mention it. I
Yes, so
skipped it.
there are actually 2 further cases, right? Renko versus Peru and Activos Mineros, and then Renko versus Peru too. So these are 2 additional cases.
They may be from a legal perspective. From a damages perspective, I was only asked to put in one report. For both, it's the same, so I count them as one.
Okay, one report on 2 cases. Okay, so that's...
Ma'am, you need to respond verbally rather than with a nod.
Yes.
Okay, any reason you didn't disclose these 2 other cases?
The 2 Renko cases?
Yes.
Because when I presented my first testimony on this case, I was not yet engaged on those cases. So my updated CV now shows that.
Okay.
But I do have the Renko case in my CV as consulting, because I know that case goes on way back, and I have it somewhere in my CV. I can look for it. But I was just acting as a consultant, not as a damages expert.
Okay, but on Renko, just to clarify, you are now acting as an expert on financing and accounting.
That's right.
Okay. Are there any other cases which you have not disclosed to this tribunal where you are acting as an expert for Peru?
No, the last one that would have fallen out would have been Renko, because Worth is here, right? Is Worth not here? No, okay, Worth versus Peru would have been another one. Because I was engaged after I presented my first report on this case.
Okay, so that's 12 cases. Any where you are acting or were appointed by Peruvian state-owned entities?
Nope. No.
Okay, and in addition to these 12 cases where you have acted for Peru, have you also recently pitched to work for Peru or Peruvian state-owned entities in other cases?
I've presented several pitches to Peru. I don't have that information with me. I don't know if I was pitching it to an entity or to the state, so I can't remember. But yeah, there's several.
But you regularly pitch to work for Peru?
I do, yes.
As a matter of fact, Peru is your #1 client, isn't it?
No. In terms of revenue, depending on the time, I would say is top 5. In terms of profit, I would say it's top 10. And then that's just my personal, as a practice that I co-lead. I would say it's top 10 in terms of revenue, top 20 in terms of profitability. And then for Alex Partners as a whole, I'm afraid it's just a rounding error.
Now, if I look at the cases that you have in your CV, 12 out of some 43 cases that you have disclosed here are where you're working for Peru, correct?
Yes.
So that's roughly 25% of your cases.
Yes, I try to keep my cases to be approximately half on behalf of claimant and half on behalf of respondent. And my respondent is Peru, and I've done work for, I'm currently working on behalf of Panama for one. And then in the past, I've done a couple other states, but all my other cases are claimants, and they're all over the world in Latin America. And several of my mining cases have been claimants.
Okay, but it seems also that the love with Peru is mutual. I mean, you seem to be Peru's favorite expert, right?
I don't think so. They actually, I pitch all the time and I lose all the time, those pitches. So I don't know what the total tally is, but I wouldn't consider myself their favorite. They also have a lot of construction cases, which I don't.
Well, out of 37 exit cases in which Peru was the respondent, you acted as an expert in 9 of them, right? That's, I mean, you're the accountant, that's roughly 23%, right?
Right, but you said their favorite. I was just thinking, am I their top? I don't think so. I think there are others.
But you're a favorite expert, aren't
I am
you?
one of their favorites, yes.
Okay. Now, you've included the current case within your expertise as a testifying expert. Let's take a look at it and how you describe it. Page 74. So here you say you were engaged as a damages and valuation expert on behalf of South American state to rebut a $50 million claim brought by a Canadian mining investor or mining company, right? You see that? So your instructions in this case are to rebut Lupaka's damages claim?
What I mean there by rebut is that I've been engaged by respondent, not by claimant. So to present would be if I'm working for claimant, and to rebut. Yeah, I mean that was my instruction to look at accuracy's testimony and present my opinion in rebuttal of that testimony.
Okay, so are you suggesting that in presenting your opinion to rebut the claim, you are finding all counter-arguments that you can?
No, not at all. I'm not using the word rebut as in a legal way. I don't know if there's a specific definition. And I don't argue. I present opinions and observations, but I don't argue a case.
Okay. Good. Let's go to that. We'll come to that in a minute. Now, let's move on. In your expert declaration, Ms. Kunzman, you say that, and can refer you to it at page 72 of your first statement. You say that all matters upon which you have expressed an opinion are within your area of expertise, right?
Correct.
And then if we take a look at your second report, page 2, paragraph 6. You're saying that you're responding to Accuracy's second report and the Micon report. Do you see that?
Well, hold on. Let me just read the sentence.
Sure.
Yes, if you read the paragraph from the beginning, it says this report is in response to Accuracy's second expert report, and that claimant also submitted an expert report by Micon containing opinions related to the planning, production, and operation of the Invicta project. This report responding to the Accuracy's second report and the Micon report, because in order to respond to Accuracy, you need to review Micon's report because they based most of their assumptions based on Micon. So we needed to understand what those assumptions were. And we looked at the Micon report from a valuation perspective, due diligence perspective, not from as a mining expert, which I'm not. We're not.
Okay, so I just wanted to clarify that the Micon report is a technical mining report, right?
Yes, but technical reports like the PEA and the pre-feasibility study and a feasibility study, those are reports that are produced for valuation experts and finance investors, right? And I consider I am an expert in that field, so I am the user of those reports. So that's how I'm looking at it.
Exactly. You're using the outputs of these technical mining reports as the inputs for your valuation, correct?
Right, just like Accuracy does.
Okay. And technical mining, as you said, isn't within your area of expertise.
No.
And it isn't in yours, Mr. Lee, either.
No.
Have you been advised by a technical mining expert when reviewing the MICON report?
No, I have not.
Now, moving on to another topic that seemed to refer a lot in your two reports, social license. Now, you mentioned, I counted it, and forgive me if I have overlooked one or two, but you have around 50 times in your two reports you mentioned social licensing. Just to clarify, you are not an expert on social licensing, are you?
I am not an expert on how to obtain a social license, no.
And you're not an expert either on whether a social license is required and to what extent, if any, it is required?
A social license from a valuation perspective is required. From a legal perspective, no, I'm not an expert, but from a valuation perspective, you do need a social license to operate for a project to be successful.
Can we agree that this is an assumption that you rely on and that this assumption or the extent of the assumption is disputed?
No, it is not an assumption. For example, I was just at PDAC in Canada, the annual conference on mining, and one of the main topics was social license and how social license impacts the performance of mining. And not obtaining a social license can destroy the value of your mine. So, yeah, I can evaluate it from that perspective, and a social license is critical.
But when you evaluate it, you're doing it under the assumption that you need to obtain a social license, correct?
You need to obtain acceptance by the community of your project, which that's how I define social license.
Now, let's turn to this topic, social licensing. Now, I'm not interested in your views as to whether Lupaka needed a social license and to what extent it needed one from Paran, as you are not an expert on social licensing. What I want to explore with you, however, is how to deal with the social licensing risk in terms of valuation. Now, would you agree with me that when valuing the fair market value of an asset like a mine, using a DCF analysis, you can capture the social license risk either in the discount rate or in the cash flows?
Correct.
And when the actual costs to acquire and maintain a social license are known, or when it is possible to reasonably estimate these costs, you would probably model these costs explicitly in the cash flows, right?
You would model them in the cash flows, but if it's an estimate, you would also have to account that it's an estimate on the discount rate. So
exactly. And when these costs of acquiring the social license cannot be reasonably estimated, or when there is some uncertainty, then, as you said, the social license risk would be reflected in the discount rate, correct?
It would be mainly reflected in the discount rate, yes.
Okay. Now, if you reflect the social license risk in the discount rate, you would reflect it in a way quite similar as how you deal with other permitting risks or other completion risks in a mining project at a certain development stage, right?
you would add a premium. It depends. It would need to depend on the due diligence that has been done at that point in the project to understand that risk. So if I were valuing a mine, I would ask the management to walk through the the authorizations or permits that they need, which ones they have obtained, which ones they haven't, and how long it would take. And sometimes they point to someone like Mrs. DeFore that does that, and they would say, oh, we have this report from this person.
I probably have expressed myself not clearly enough, but in terms of the evaluation exercise,
Yes.
then determining which discount rate you want to apply in general, you would deal with the social license risk in the same manner as you would deal with any other permitting risk, correct?
You would add a premium, yeah, to the discount rate, yeah, for both.
Because there's always the risk that a permit would not be granted, correct?
Yes, but the risk for a permit is usually not binomial. The risk, so you either get it or you don't. A lot of times is time or cost. Most often that's the case.
And that would apply to social license too, correct?
Social license is different in that once you have a permit, it typically doesn't get removed, right? You have it and it's done. With social license, it's different because you have to maintain it throughout the project. So you have to understand very well how the community is before your project, and then how the project will affect that community at each stage, so you know when your social license risk is higher or lower. So sometimes in a case, the biggest part of the social license risk is when you're closing the mine. Other times is at the beginning. It depends. So it's different than the permitting in that regard.
But a permit may also be revoked if you don't fulfill the requirements anymore, right?
Yeah, but I wouldn't call that a permitting risk. I would call that an execution risk more than permitting, because you do get the permit.
If you fulfill the requirements.
Yeah. I mean, if I think in evaluation, there's a chance that the company is not going to fulfill their requirements, that's a different type of risk. Like I said, that's more of an execution or owner risk. I'm not sure.
So if you add a premium for permitting risks, you assume that the owner has a right to the permit, but that for some reason it doesn't get issued within the time that the owner hoped.
Yes, but you're assuming that I would add permitting risk through the discount rate.
Yes.
I wouldn't, because permitting is something that should be very clear to the owner of the mine on what the requirements are. So, for example, the SRK report already put in what were the permits that were required. So it's not something ambiguous like social license risk. Certain aspects are more ambiguous, but with permitting it's not. And you can get an estimate of, okay, what is your best case scenario for permitting? What is your worst case scenario? And then in speaking with the mining operator, you come to a decision that you think is reasonable, and you start projecting your cash flows from that date.
Okay, so just that I get you correctly, you wouldn't include a permitting risk in the discount rate. That's your opinion, isn't it?
I would try to model it directly into the cash flows, unless an expert on permitting tells me, well, this permit is going to be, I have no idea whether we're going to get it or not, and then, yeah, I would put that.
Now, let's explore together how social license risk is reflected in the discount rate. And let's go to your second report, page 69, paragraph 231.
Second report, page 69. Yes.
Okay.
Oh, wait, what paragraph? 231.
231.
Yeah.
You say here that, quote, the fact is that most countries in this region face persistent conflicts due to the insufficient consultation with affected communities. You see that?
Yes.
And when you say this region, you mean Latin America, right?
Yes.
So this means that generally speaking, Latin America countries face social license risks. Is that what you're trying to say here?
Mining reflect social within mining, yes.
Within mining.
Yeah.
So in Latin American, or before I get there, so are you saying that social license risks differs based on the geographical location of a specific mining project?
They can, yes. If you're putting a mine where there's no population around, you have a lesser mining risk. Yeah.
Yes, you would.
Or for example, if you have a project, it's a company's second project and they already have social acceptance from a prior project nearby, that second project would have lower social license risk.
Let's focus again on the area or the region, because I think what you're trying to suggest here that mining companies in Latin America are facing a specific social mining risk.
Yes, that they face social mining risk. Yeah, most mining companies face social license risk, but the degree varies, and the degree that companies manage that risk also varies.
Okay, so you have social license risk as well in, let's say, the US or Europe, but it's more pronounced in Latin America. Is that what you're trying to suggest here?
I'm not making a comparison. I'm just saying in Latin America, mines face persistent conflicts due to insufficient consultation with affected communities.
Okay, and not sure I fully understand you, but let's try to get to the bottom of it.
Okay.
And probably looking at the first sentence and putting into context what you're saying here is, do I understand you correctly that it is your view that indices such as the investment attractiveness index rank mining risks by country? Is that that's what you're saying?
Yes, and I'm actually going to pass the question, if you're asking a question about the index, to my colleague.
Okay. Now let's look at the footnote you refer to, footnote 205. You refer to this investment attractiveness index, which is an annual survey by the Fraser Institute, I understand.
Yes.
Okay, let's go to Exhibit AP 75, and you can find that at tab 46. Now, if I look at AP 75, This is only an executive summary, isn't it?
Yes.
But I take it that you have also, or Mr. Lee, maybe, rather, has also read the underlying survey, right?
I think we just appended the executive summary in this case.
Yes, you appended the executive summary, that's correct, but you're aware of the survey itself, correct?
I'm aware of the survey, yes.
Would you agree with me that in that survey, we don't have it on record, Peru actually ranks quite high, at least through 2019?
Highly ranking as in more attractive.
More attractive, yes, actually,
Yes.
quite attractive.
Yes.
In fact, it was, I think, the second most attractive country in Latin America behind Chile. Would that sound about right?
Yes.
So it was regarded as a quite stable country, right?
In the survey, yes.
Now, did you notice that in this survey, I'm very sorry we don't have it on the record, the Peru's policy perception index actually declined dramatically in 2021 and later on?
I don't have the survey in front. I couldn't say.
Any reason why you didn't include the whole survey?
I don't think it was relevant to the point that we were making in that particular paragraph.
Okay. Now, let's look at how one estimates the discount rate that should be used in a DCF calculation. And
I have you left the topic of social approval?
no,
No,
not
no, no.
no. There's actually quite a long line
All right.
to follow now, where I deal extensively with
Please signal when you are done with the topic, because I have a question. But I don't
Sure.
want
If you want to do it now, I'm very happy for you to interject.
I don't want to preempt what you're trying
Okay.
to do. Thanks.
Yes, but it may take another half an hour. Okay. Are you ready? Okay. Now, would you agree that to calculate the discount rate to be used in a DCF analysis, you would first have to calculate the WACC of a hypothetical gold mining entity in Peru? And just for the benefit of the uninitiated, the WACC is the acronym for weighted average cost of capital.
It depends if I'm valuing the entire enterprise or I'm just valuing the shares. I would use the WACC if I'm valuing the entire enterprise, or the cost of equity if I'm just valuing the shares.
Now, I mean, we don't have to do this all by heart. I mean, I'm very happy for you to look at the accuracy report, page 89, maybe also for the benefit of the tribunal. Maybe
First
easier.
report?
The first accuracy report. You find it at tab 4. Sure, you know this all by heart, but just maybe for the tribunal it's easier to follow. A relatively technical line of questioning that's coming now. Now, when looking at what accuracy has done to calculate the discount rate, they use as a starting point the average cost of capital for companies in the precious metals industry based on data from Professor Damodaran, right? It's page 89. At tab 4, yes, that's the first accuracy report.
Right. So in their first report, they used the CAPM, the capital asset pricing model, to calculate the cost of equity based on the average cost of capital for companies in the precious metal industries.
Yes, and
From Professor Demadron, what they mean from Professor Demadron is that they're using the beta from calculated by Demadron.
okay, and using beta data or this discount rate data from Professor Damodaran is fairly common in your industry, isn't it?
Yes, I use Demadron as well for betas.
Now, you mentioned that accuracy used the CAPM, the capital asset pricing model, to calculate the cost of equity. Now, to do that, you calculate the cost of equity on the basis of a risk-free return plus an equity risk premium, right? That would reflect the return of an equity market portfolio over a risk-free investment, right?
Right.
And then you adjust this equity risk premium to the specific industry you're looking at using a factor called beta.
In the United States.
Yes.
Yeah.
And this beta factor measures the sensitivity of the specific equity you're looking at or you're trying to value compared to changes in the market return overall, right?
For companies listed in the United States, yes.
And to calculate this factor beta, you would typically look at actual market data from companies operating in a similar sector as the one that you're trying to value, correct?
It's a sector average. You would try to approximate as much as you can. Yeah.
And the beta used by accuracy on the basis of Professor Damodaran's survey for precious metals industry is 1.19 for 2019 and 1.44 for 2020. You would agree with that, right?
Yes.
Okay. So just for the tribunal to understand what this beta means, this beta factor. Now, in layman's terms, the precious metal industry, since the beta is above 1, would face higher risks than the general market, right?
Yes, it has a higher volatility. Yeah.
Higher volatility. And that beta includes all kinds of risks.
All kinds of risks.
All kinds of risks, including social license risk, correct?
Yes, it includes an average of all the risk that the companies that Demadron uses in calculating the betas, which he lists, that are traded in the United States. Yeah.
Correct. Now, accuracy have found that 40% of the companies surveyed by Professor Damodaran have operations in Latin America.
We could not evaluate that statement because they didn't submit the analysis. It was just a statement without a list of the companies and which ones had it and to what extent they had. It was just an unsourced statement. So I don't know.
Have you checked the statement yourself?
Yes, I have.
And
no, have I calculated? No, I did not. No.
Now, just assume with me, and I know you may not agree with this because you haven't checked with it, but assume with me that accuracy is right, that 40% of these American companies in the survey have operations in Latin America. Now, if social licensing is a problem in Latin America, the beta, at least for those companies operating in Latin America, would actually include a social licensing risk.
That beta, first of all, I would need to understand if one company if when they say they have operations in Latin America, is it 1% of their operations or is it 80% of their operation? It really changes. And then I would need to check where the other operations are. I mean, maybe the other operations are in countries that have other issues, right? And the beta, like you said, contains so many risks. I don't know to what degree the social license risk is represented. And the list of the companies that that the mod run includes, these are companies, a lot of them are majors with a lot of projects. So it's an average. Is there some social license risk included in there? Absolutely. But is the specific social license risk that Invicta faced included in there? No, not in the beta.
Okay, help me to understand your answer. You're trying to distinguish a general social licensing risk from a specific social licensing risk, right?
Right, because the beta is an average. So then you're dealing with average and it contains all types of risk.
Yeah. And these social licensing risks may be higher for some companies and lower for others.
Right, it gets diluted so much that you don't know to what degree. There is some, but there's also pricing risk, cost changes risk, earthquake risk. I mean, there's so much in there. And I haven't seen anyone that has tried to desegregate the beta risk, and that's why companies, I mean, that's why valuation professionals add premiums.
Mm-hmm. Now, I think if I understand correctly what you've said before, you've said, and I don't want to misquote you, that, you know, there's no question that a mining company needs a social license.
Yes.
So if that statement is true, then, you know, typically all mining companies would need social licenses, correct?
Yes.
So the beta would actually include that risk on an average, but it would include the risk, as you say before.
Right, but you're making the jump there that all companies face a social license risk that is the same. No, for one company it might be much easier to obtain a social license than for another.
Okay, but some social license risk is included in the beta. Can we agree on that?
Yes, yes. I mean, and I don't think there's a dispute amongst the experts on that. They've said it's the average risk of a hypothetical mining company. Yeah, we agree with them.
Okay. Now let's discuss country risk premiums. Now, when calculating the cost of equity, Accuracy has added a specific country risk premium, right?
Yes.
Would you agree with me that the country risk premium is the additional return or premium an investor would require to compensate for the risk of doing business in a certain country compared to a risk-free country like the US or Canada?
Almost. I would just
Almost?
take out a risk-free country. I would just say compare it to doing business in the United States. United States is not a risk-free country, but because your capital, all the other variables in CAPM are done based on the US, then it is compared to the US.
Okay, because you say that the US is not risk-free because the US also contains risks like social licensing risk, right?
No, because when you calculate your CAPM, you're adding the equity risk premium. That's what I'm saying, that it's not just the risk-free rate.
Okay, and Accuracy have taken that country risk premium from the Modern data again.
Yes.
Right. Now, would you agree with me, Ms. Kunzman, that the country risk premium reflects the political and economic risk for a country?
Political, economic, yeah.
And the political and economic risk is, at least to some extent, linked to social stability, isn't it?
Yeah, there's some social risk in there too.
Now, the CPR, I think we agree on that, does reflect social stability to some extent.
For the average investor in Peru, so yeah.
And social licensing is a function of social stability, isn't it?
It's different. It's definitely affected by it, but social license risk is different in that depending on your type of business, acquiring a social license may not be as difficult because the impact of that specific business in the community is very small. For a mine, for any extractive industry, it's big because of environmental issues, water usage issues, labor issues. So some companies may not be as big. If you're, I don't know, trying to think of a company that may not have as
A bakery, I guess.
a bakery, for example. Yes,
So a bakery wouldn't be affected by a country risk, right?
a bakery would not be as affected by country risk, but for example, a bakery would be affected more by the prices than by the exchange rate, and a mining company wouldn't be because their cost and revenue are typically all in US dollars. So country risk, it contains a lot and you need to unpack it. I think their country risk is fine, but I would have unpacked it a bit more.
Let's look at the impact of the country risk premium that Accuracy has applied. They have applied a country risk premium of 1.4%. Now, would you agree with me that this country risk premium reduces the net present value by roughly $3 million?
I haven't calculated, but that sounds right. Yeah.
Okay. Now, let's move on to the pre-production premium that Accuracy adds to the WACC to get to the discount rate.
Yeah.
I think you touched on that as well in your second report. At tab 2, page 39, it's paragraph 134. So if I look at that, you take issue with Accuracy's pre-production premium of 3.3%, right?
Yes.
Now, if I look at the next paragraph, paragraph 135, I think you would have preferred a pre-production premium of 5.7%.
Correct.
Okay. Now, before we discuss the appropriate figure, let's try to agree on why you would want to add a pre-production premium to WACC. Can we agree that by adding a pre-production premium to the weighted average cost of capital, that this is an adjustment to capture the different stages of development of a mining project compared to an actually producing mine?
I would say it's an adjustment to the different levels, excuse me, of study that have been done on a project.
So you would only refer to it as a study and not as the development risk?
Yes.
But how does it make sense, Ms. Kunzmann, from an economic perspective, to look at studies rather than the reality?
Because these businesses are not operating yet. Mines get valued by Symbol based on scoping studies, pre-feasibility studies, or feasibility studies. And the assumptions that go into those studies have a margin of error. We have a figure in our report that shows what's the level of confidence of the inputs that goes into those studies. So because the mines are not producing, you have to rely on those studies. If the mine is producing, absolutely you would rely on the actuals, but until that point, all you can do is rely on studies. So it's the level of confidence of that particular study. And this is general, right? Each study may contain more or less information. So you would need to look at the study to see, okay, does it take into account, have they done a detailed study of permitting or social license risk? That it's the study that you're relying on.
So you're saying, you're telling me that it's only the study and you're not looking at actual risks at that point in time?
You're only adding a premium based on the level of study. So you look at the study, see what the margin of error is and the type of study that it is, and then based on that, you may need to add another premium on top of that, or ideally, you model your cash flows to account for other risks.
Okay, but let me try to understand this. So you say you have a feasibility study or whatever level of study, and the reality shows that your assumptions in that study don't hold true anymore because you have moved on from that study.
If you're producing,
not producing, if you're still at the pre-production phase, at the pre-production stage.
If you're at the pre-production stage, no, you wouldn't move from that study because you're still pre-production. You're just taking out small samples. And you still don't know fully your cost. And if your valuation is based on the output of that study that you're relying on in terms of what your costs are going to be and your capital expenditures and your grade and production, then it is the level of that study that you need to rely on. But if you modify your calculation to take into account, okay, so we're in pre-production, we thought this was going to, we were going to have this grade, but now we have this other grade, we've modified our grade based on the actual production, then yeah.
Then you would take into account the actual facts rather than what you have assumed
for
in the
that
study,
specific
correct?
For that specific item, but there's still a lot of risk on that study.
Okay.
So where's the table?
I'll get to that table immediately.
Oh, okay.
Don't worry. I'll maybe not immediately, but in 2 minutes. Now, would we agree that the risks to be captured in that pre-production premium are the risks associated with bringing this mine to production? Or this project to production?
Yes, but the studies make certain assumptions, like all permits will be acquired, or that they will have certain contracts in place, or that there will be already social acceptance by the community, and that's why there are disclaimers in the studies. So those studies deal more with what mining experts deal with, which is the mineralization, the cost of taking out the ore, the cost of the capital, of the PP&E.
But you would agree with me that there is a risk at every stage of the development of a mine or mining project. There's a risk that the project will not make it to a producing mine. Correct?
Yeah.
Yes. And that risk of not making it to a producing mine becomes lower the closer you get to production, correct?
It depends on which risk you're talking about.
I'm looking at all risks associated with bringing a mining project to production. Technical risks, permitting risks, construction risks, geological risks.
The closer, getting closer to production is a very broad statement. So if you go to permitting, it's a yes or no, whether you have the permit or not. Maybe you don't need your permit.
Well, haven't we agreed that, or haven't you said before that permitting is not a risk that you would usually?
No, you're right.
Look at-
I would model directly. I would look at the risk, but I would model it directly into the cash flows.
Okay, so we are looking at technical risks, construction risks, geological risks.
Those are all included in the level of study. Yes.
Okay, and you would agree with me that the closer you get in your level of studies to production, the lower these risks are getting.
It would depend on the level of study. Because
Yes.
the risk doesn't change if you don't have, and I know if you don't have a license to operate or to sell the ore, you can't just, your risk are not going to materialize or materialize more on a specific date. Up to that date, whether you're a month before or 2 weeks before, it doesn't matter because you have a very specific production date.
I'm not sure we're talking about the same thing, Ms. Kunzmann.
Okay.
You were talking about these studies, and let's maybe go to that table.
Okay.
Figure 5 on page 15 of your, I think, first report. Is that the table you were referring to?
Hold on, I'm not there yet. Figure 5, page 15. Yes.
Okay.
Counsel, could you give us a minute to get it, please?
Sure. That's,
And the site again, please.
so that's Alex Partners' first report, tab 1, or you may have it separately. Page 15, figure 5.
Thank you.
Now at the top of this table, you're listing the different stages of studies, correct? Preliminary economic assessment, pre-feasibility study, feasibility study, right?
I'm listing the 3 levels of
Yes,
studies.
3 levels.
Yeah.
And do we agree that the further right we get, the closer we get to production?
The further right you get, yes, but as for example in Invicta, you might get to production without a feasibility study or pre-feasibility study. So not all companies will do all the studies. Some may not. They may go directly to a feasibility study without going through the others. I mean, it's rare, but you can skip, basically.
So you can skip studies and actually base your investment decisions on the real facts you're observing rather than doing another study, correct?
If you can update the facts in the study based on real observations, then you would. But that's not what happened here. They're still relying on that initial study that was done.
Okay, can we agree, maybe just take it one by one, that the further to the right we get, the more you have de-risked, the more you are de-risking a project?
A feasibility study has de-risked the project more than a preliminary economic assessment. Yes.
Now, let's have a look at AC 47, page 18. That's on in tab 35. Now,
I see 47, page 35. Okay.
this is a conference paper presenting the results of metal mining industry surveys, which indicate common industry practice on discount rates used at different stages of the projects. And if you look at slide 18 or page 18, we see that the pre-production premium for a producing mine is 0%. Then we have 3.3% for a project at feasibility study level, 5.7 at pre-feasibility, and then 6.9 at scoping study PA level, right?
Right.
Now, you would agree with me that these premia that you find here include all risks depending on the stage of development to bring a project to production, right?
No.
Can you explain to me which risks would be included in this pre-production premium and which risks would be excluded?
Like I said before, it's not a risk that's based on the stage of production. It's a risk that's based on the type of study that you have done.
Now, please, yes.
The subject, because I find it rather difficult to understand as a layman all of this. Suppose that we have a study. I don't care which level of study it is, but it is in the pre-production stage. Now, suppose that this study says, well, to get to production you need A, B, and C. So, and on that basis there is a risk. The risk that you won't get A, B, and C to start production. All right, fine. So you assess the risk on the basis of this study that talks about A, B, and C. Now, if assume that after this study, the company gets A, so the two things that are missing are B and C. Is it rational to say that, well, the risk has diminished a little or not?
No, because what you're doing is, if you go, it's simpler if you go to figure 5. Those studies, what they do is that they will estimate the type of minerals that you have, right? And they will estimate based on that mineral that you have, how much you're going to be able to extract and you're going to be able to sell. So in all of that, they're estimating how much ore you need to take out, how much, what the grade is going to be, what the yield is going to be, how deep you're going to need to go, how many tunnels you're going to need. In making those estimates, they will assign a confidence level to them. And the confidence level for a preliminary economic assessment is lower.
I understand that.
Okay.
But using your example, if the tunnels are already built,
yes,
okay, then that part of that study, which was an estimate at the time the study was made, is no longer an estimate, it's a reality.
Right, but
Can we take that into account or not?
I would update the study
Yeah,
based.
but there is no updating of the study. There is no, the study has not been updated. We have to assess the situation with that old study not updated and those tunnels have been built.
I would say I would still need to look at that study that was done and take the Excel and figure out, I would model the cash flows based on my actual data, figure out the impact, and possibly reduce the discount rate with that level of study.
That's where I wanted to get. Thank
Yeah,
you.
yeah. Yeah, but just to clarify well, no, that's fine. Yeah.
Just an observation, we're about 2 or 3 minutes out from the scheduled lunch break. If you can come to an appropriate point to suspend the examination.
Then I would probably do it now with your permission, Mr. Chairman.
I suspect you'd get relatively little dissent around the room for that. So. All right. Well, then let us rise for our 40-minute lunch. The experts, I'm sure, are familiar with the procedure and know that they should not discuss their testimony, the questions being asked with anyone. I think they can discuss it with each other. I think they can discuss it with each other. Yeah. Is that agreeable? Can they discuss the questions with each other? Does sequestration mean they can't talk to each other? Seeking the views of parties here.
Probably yes.
Say again?
Probably, I'd prefer if they talked about the food or the lovely weather, spring in the city, rather than.
All right, so we will confine.
Mr. Chairman,
say again?
We have a different view. If we may be heard on the issue.
Do we want to delay people's lunch on this issue?
I believe yes.
Okay, I guess we do. Please.
Yes. We do not agree with the submission by Claimant's Counsel. The experts here have submitted a joint report. No questions are being posed going forward that they're discussing. Obviously, they don't have a crystal ball. The instructions was that a question was posed, only one may answer and the other may not supplement. But everything that has been discussed up until now should be available for the experts to discuss.
I'm sorry? I'm sorry, I can't hear you.
Your microphone, Mr. President.
The experts should confine themselves to the subject of the quality of the food and the state of the weather. And we will see you all in 40 minutes.
Understood. Thank you.